And today on Ramblings with Rebecca, it's treaties! As you may remember, this week we are doing a series on sources of international law. Probably one of the first things that comes to most people's minds when they hear international law is treaty. Yes, your good old convention, covenant, agreement, pact, charter, exchange of letters, protocol, whatever. Many different names. Basically, they're all treaties. All of those forms of agreements, regardless of what they call themselves, basically treaties, equal to the same, the rules are the same. Treaties, agreements between states that are ratified by their state governments, in some ways comparable to a contract. Willing participation, sign on, agree to be bound by the rules. So 1. Treaties are legally binding. They are one of the clearest sources of international law that is binding, because states agree to them and say, we're bound by this. And that's the whole point of a treaty. 2. Generally speaking, they're some of the easiest things to point to. It's very hard for a state who is, signed on to then say, no, that's not law. So this is kind of the fallback, the easiest to use, the hardest to refute if you're trying to clarify what is and is not international law. We'll look later this week at some sources of international law that are much more vague, unwritten disagreements about whether or not it is or is not binding, whether it is or is not law, that kind of thing. But treaties, for the most part, they're signed, they're explicit, they're, ratified by the states, they are law. That does not, of course, mean that there is a nuance and that there aren't still questions of interpretation, and so on and so forth. International courts exist for just that reason, to help figure out what the treaty actually says, and what states actually meant, and did or did not agree to, and whether or not they have or have not, complied to the obligations they set forth. A central document in international law is the Vienna Convention on the Law of Treaties. Yes, it is in fact a treaty about treaties. From 1969, a bunch of states came together and said, look, this is how we're defining a treaty, this is what treaties are bound by, that kind of thing. But because international law is consent-based, the only way to define treaties was to make a treaty about them. It's a beautiful system we've got. But so that has really become a central source in international law, to be able to look back and say, look, this is treaties, these are treaty obligations, here are yours. A little bit more vocabulary. Signature. A state can sign a treaty pretty much any time. It is not necessarily an expression of an intent to be bound by the treaty. A state can sign a treaty, but that doesn't actually mean it is bound. Signatories, not necessarily parties to the treaties. They are only bound once they have gone back and ratified in the domestic government. Ratification means you're bound. Signatories mean, yay, hurrah, I put my name on something. Generally speaking, Parliament has to agree, or the equivalent. This isn't true in all countries, but that's the basic shindig. States are then bound by that treaty once they have ratified it until they formally repudiate it. Some treaties don't allow for repudiation, but for the most part they do. There's some kind of, here's what to do if you no longer agree with these terms kind of clause. As of course there are in most contracts. 2 central rules of treaties. 1, states signing on are bound and need to work on it in good faith. For the most part, breaches of treaties are tricky to prove and are often in international law tied to some kind of intent, right? The treaty is a sign of good faith, and states have to work towards not breaking it and towards implementing whatever they've agreed to. This comes up a lot in human rights treaties, right? Like a state that has ratified a human rights treaty is not, and instantly incarcerated if there's a single human rights obligation, right? But there's this process of good faith. And there's, of course, then all kinds of technical rules about when it is and is not clear that, states are working in good faith, and when you can and cannot slap them for it. And then, of course, there are political rules as well, right? About, whether or not a country is going to bother taking another country to international courts to slap them for being in breach of a treaty. Other rule number 2, states that have not become a party are not obligated. States are only obligated if they've contracted to do so. This is back to the consent, right? Treaties cannot bind non-parties. It is only parties that are bound to treaties. We should go with the human rights example. States that haven't signed on to be legally bound aren't legally bound. And this is one of the main problems in international law.